Hi, everybody. Welcome. Thanks for joining us for this webinar. We're here today to talk about detention under INA Section 235B, the current landscape in federal and immigration court. I will toss it over to Andrea quick to see if there's any logistics or housekeeping we need to deal with. But if not, I think we can just go ahead with introductions. This is being recorded. And I will just introduce you all so we can save some time since we have a lot to get through in just about an hour. So I'm Suchi. I'm a senior litigation attorney at the American Immigration Council, along with my colleague Rebecca Kassler, who has the same position. We work together a lot. Then we have Becca Wolf, who is director of the Immigrant Justice Campaign. Thank you, Becca, for being here, which is also going to house within AIC. And then Shayani Maitra, thank you so much for joining us, Shayani. She's a supervising attorney of federal practice at the Immigration Law Unit at the Legal Aid Society in New York. So with that, I think we can get started. If you all have any questions, please put them in the Q&A, I believe, and we will try to address them or while we talk, if it makes sense, or at the end. We're going to try to reserve a few minutes for Q&A. So let's see if I can manage, yes, to get to the agenda. So we're going to start off today talking about Section 235B, both subsection 1 and 2, when do they apply, how the government has really expanded who is subject to these provisions in recent months. Then we're going to move on to, is release at the agency even still possible? And Becca is going to talk to us about both parole and bond, what that looks like at the DHS and the immigration courts. And we're going to shift over to where individual habeas petitions have been successful in litigating detention under 235B, and Shiny and Becky and I are going to talk through some issues there. And we're going to end with a very brief overview of some of the class litigation challenging DHS's new interpretation of 235B. And we are hoping, like I mentioned, to save a few minutes for Q&A at the end. So with that, I'm gonna hand it over to Becky.
Hi, everybody. Thanks for being here. I just want to flag at the outset, today we are not going to be delving into the question of who is properly subject to expedited removal, even though that falls within INA 235B1. Who is the government trying to put into ER now, whether it's lawful? All of that is being worked out in litigation. So you can look at the practice advisory that's on AIC's website that covers 235B detention. Pages 8 to 13 discuss placement in expedited removal and cite a number of pieces of pending litigation on this question. The Churla v. Nome case, Make the Road, IARC, and African Communities Together. So look on those pages for those cases, but just know that's kind of not what we're talking about today. Instead, we are focusing on the various provisions in 235B1 and 2 that authorize or mandate detention and how to challenge that detention. First, we've got detention arising from expedited removal, and there are two subsections of 235B1 that are relevant. The first is the one on the slide, B1, B3, 4. This applies to people who are in ER proceedings. So they're waiting for a CFI or they're waiting for IJ review of their negative CFI. In theory, this is supposed to be short. There is a settlement in the Padilla litigation in the Western District of Washington that requires CFIs to happen relatively quickly, or an NTA is supposed to issue. So that's something like 70 days. It's not short enough, but people aren't supposed to be sitting in detention under this provision forever. I won't talk about that until removed piece here. That's a little bit murkier, but please see page 24 of our practice advisory for a brief discussion of what that might mean. Next slide. A different subsection of B1 mandates detention after CFI or after a credible fear has been established. And the applicability, you can go to the next slide, of this provision has evolved over the years. And I want to flag one regulatory definition that's relevant to this discussion, the definition of arriving alien. And that's an applicant for admission coming or attempting to come into the United States at a port of entry. So through a port is what's relevant for arriving. And so here is kind of a brief, oversimplified timeline of how this statutory provision has been understood over the years. We got expedited removal as part of IRA in 1996, and for the first 8 years of that statute's existence, only people who were coming at ports, largely speaking, were subjected to ER at all. And then in 2004, the administration expanded it to some people who entered without inspection and were apprehended relatively soon after that. And very soon after that happened, the issue bubbled up to the BIA. Well, are these people eligible for a bond hearing after they establish credible fear? And in matter of XK, the BIA said yes, they are, consistent with long-standing regulations, making only people who are arriving aliens ineligible for bond. Everybody else could seek and receive bond through a hearing before an immigration judge. All that changed in 2018 with the Supreme Court's decision in Jennings. There, the Supreme Court put forward a new reading of this statutory provision. And there they reasoned that the language in the statute, detention for further consideration of the application for asylum, doesn't just mean that people are detained until those 240 proceedings start. It means detention through those proceedings, including any appeals. So this really worked a sea change in terms of bond practices in the immigration courts. And in 2019, we saw in matter of MS that the BIA adopted that new position set out in Jennings. And now we're where we are today, which is everybody who was placed in expedited removal, regardless of whether they came through a port or not, is ineligible for a bond hearing, though there is certainly litigation challenging that. So there are open questions about this, who's even subject to ER, as I mentioned, and whether any of this is constitutional. But what the statute means is now, unfortunately, somewhat settled based on Jennings. And as I mentioned, we're not exploring, the scope of those questions in this webinar any further. Separate from ER, we'll move away from expedited removal land and talk about 235B2. This is the other major detention provision in 235B, and before this year, it really got very little airtime. Here, the statute mandates detention for applicants for admission who are seeking admission. So let's move to the next slide. The statute defines applicant for admission and admission. An admission is a lawful entry after inspection and authorization, whereas an applicant for admission doesn't really depend on this definition of admission. Go to the next slide. An applicant for admission is its own special term. It includes people who arrive in the United States, as well as people who are present without admission, so people who haven't been inspected, anyone who entered unlawfully. Next slide. So going back to this detention provision in the statute, this will become relevant to the later discussions about how to challenge detention under this statute. So again, it applies to applicants for admission who are seeking admission and who are ultimately not admitted. And historically, we can go to the next slide. This provision was applied relatively narrowly. It was understood, and there was a consensus among EOR DHS practitioners that this provision applied largely to people coming to ports of entry, or perhaps exclusively to people coming to ports of entry. That might be returning LPRs who, for one reason or another, are not who for one reason or another have to be admitted again or are considered seeking admission based on INA 101A13. And it could also be other people who come to a port, maybe they have a visa, but for some reason they're not admitted. Or maybe they don't have papers at all, but DHS exercises prosecutorial discretion not to place them in expedited removal. So those folks would be put in 240 proceedings and they could be detained under this statute. And that was the way things operated in most parts of the country for about 30 years. Then in 2022, most of the IJs in Tacoma Immigration Court started applying a totally new reading, and they just said anybody who's an applicant for admission is mandatorily detained under this section. And remember, the statute defines applicant for admission as including anyone who entered without inspection. Then we saw the BIA and ICE take notice of this in the new administration. So, matter of Q Lee, the BIA expanded 235B to some people who entered without inspection. Later, ICE issued guidance to its own officers saying, actually, no, it's all people who entered without inspection. And the BIA followed suit last month in matter of Yahuri Hurtado. Next slide. I won't spend too much time on Q Lee. I think we're all probably pretty familiar with this. Um, but the facts here were Ms. Cooley entered without inspection, was arrested the same day, very close to the border, detained, and then released on parole. And the BIA held that she was detained while she was arriving, even though she wasn't coming through a port. She's subject to 235B2, and then if her parole ends and she's taken back into custody, she's also returned to 235B2 detention. Next slide. Um, then in July, the acting ICE director, Todd Lyons, put out a memo that purported to revisit DHS's longstanding view of the statute. It has very little explanation. It's been publicly reported. This memo just says, now all applicants for admission, anyone who was not admitted before, is subject to mandatory detention under this statute. And as I mentioned, next slide, the BIA followed suit in matter of Yahuri Hurtado in September. And there, the person seeking release had entered without inspection and was arrested about 2.5 years later. And the BIA held that IJs lacked jurisdiction to grant bond in that circumstance, regardless of the circumstances of entry, regardless of how long the person has been in the country. All right, that's a lot. Are there any questions we should answer before moving on?
Becky, so after this BIA decision, I think we've seen a lot of individual habeas petitions. And is there any other way that folks can challenge someone who falls squarely under this decision? Is it viable? Is it necessary to challenge that in immigration court, or viable? Is it like raisable at the circuit court level? What options do people have?
Sure. Well, I think off the bat, since bond denials are not appealable in a PFR on their own, there wouldn't be any way for a person to take this through the PFR process. If they're going through a PFR of their merits denial, it's too late for a challenge to the detention to really have any meaning to them. That's not traditionally the way that detention decisions have operated. So there's no way to take it to the circuit court. And in terms of taking it to the IJ, at this point, most habeas courts, most district judges sitting in habeas have concluded that exhaustion before an IJ is completely unnecessary. I mean, decisions of the BIA are binding on immigration judges, right? This is a precedential decision. So barring some unique factual circumstances that call into question the applicability of Yahuri Hurtado to some individual person, I would strongly suggest that this need not be exhausted before the IJ and perhaps shouldn't be exhausted. You're going to waste time in most jurisdictions trying to get a decision on that, and the result is foreordained. It's futile to do so. I would strongly caution people to do jurisdiction-specific research on that question, though, because there are a few outliers.
Thanks, Becky. So I think let's turn it over to Becca, who's going to talk to us about what options for release still exist at the agency level and who is still eligible for release. And Becca, just a question that you can keep in mind that's in the chat is, how are most people who entered EWE getting picked up and detained? And this is something I think you probably have some experience with. And if you could share any thoughts about assessing detainment risk for folks who did enter without inspection. Thank you.
Yeah, sure. Hi, folks. Thanks for being here. So yeah, we can go to the first slide. As Becky sort of already reviewed, we're not talking about whether people were correctly or incorrectly being subject to 235B, but just sort of what happens once the agencies have decided that that's what they're detaining them under. And so there are two pathways, that both pathways still technically exist to get release at the agency level. One obviously is through DHS, which is humanitarian parole, 212D5 parole. And one is bond out of DOJ, out of the immigration courts. Both of those things, the statutes have not changed on those two issues. The regs haven't changed. They still exist on paper. So we'll start first with humanitarian parole, also just called parole because that humanitarian parole unfortunately has two different meanings. But parole under 212D5 is the release from detention that everybody is eligible for unless they're subject to 236C mandatory detention, and even then can be released for particular grounds. So this includes people who are detained pre-CFI, post-CFI, but waiting for proceedings, people who were never put in expedited removal, all of the above. 212D5 is supposed to be available to them. And this is the sort of umbrella of all parole release. So that includes sort of the generic explanation of it, which is below, right? Either urgent humanitarian reasons or significant public benefit. There are certain categories that are delineated as sort of being presumptively on humanitarian or public benefit grounds, things like pregnant women, people with serious medical conditions, minors, and witnesses to crimes. So those folks are, that is listed in the reg as people who should be presumptively determined to be released on parole. Parole is discretionary and on a case-by-case basis, right? And then there are memos. Can we just go back a slide really quick? Sorry. There are memos that are still also technically in place. The one that most people are familiar with is called the parole directive. That is applying to people who have been designated as arriving aliens and got a CFI. And that directive is under the auspices of the reg itself, but is still technically in effect. The problem is that most people right now who are detained are either don't fall into the category because it has to be both arriving alien and a positive CFI finding. Sorry, next slide. So we've done some analysis of detention stats. You can get it online. ICE, these are ICE's own numbers. Monthly average of the quarter right before the current administration took power, the average was about 5,000 people released on parole a month. That has dropped to, on average, 75. So there is essentially a de facto total end to parole, which is a significant issue if we realize sort of both that's the way that most people are eligible for release, and as we look at bond, which is the other option, is available to fewer and fewer people. So people who are detained under 236 are supposed to be able to be eligible for bond. Bond, technically, a request from ICE, a request from the immigration judge is actually a request for a redetermination of custody. ICE makes an initial determination of their custody. ICE can, again, under their own discretion, release someone through ROR or an ICE bond. Those things have also all but disappeared. Although technically the directives on releasing people for those for sort of specific circumstances are again still in place. Here are the statistics on people who are being released by ICE bond or ROR. So these are releases under DHS, not the immigration courts, but are under DHS discretion for people who are otherwise eligible and are detained under 236. Again, basically a de facto end of release by ICE on discretionary grounds. And so people who are subjected to 236 detention, and actually up until very recently, we were also arguing that people in certain categories of 235 who were not subject to QLE also would be eligible for release on bond, but that is in flux right now because of Yahure. But people who are detained under 236 are still theoretically the group of people who are eligible for bond by the immigration courts. That, of course, has been reduced by people who are detained under mandatory detention 236C. Those folks have never historically broadly been able to be released on an IJ bond. That was reduced even further by Lake and Riley. And so what's really left after Lake and Riley and the other mandatory detention restrictions are people who are considered deportable with minor criminal histories, people who are here on visa stays, and then of course, essentially anybody who has been admitted still on paper is eligible for an IJ bond. So this also, the people that we're seeing included in this are people who are in either green card holders that are in removal proceedings or deportation proceedings, or people who have visa overstays, essentially people who have been admitted. So this is like sort of immigration judges across the country are treating some of the exceptions very differently. So it is jurisdiction based, not just by the circuit courts, but also by each immigration court jurisdiction.
Yeah, thanks, Becca. I think before we move on from the slide, I can elevate a question from the chat, which is what can be distinguished for formerly unaccompanied children? How can you argue that they're still eligible for a 236A bond? And I can take a stab at answering that. Sure. So there's been some practitioners who have reported success arguing to IJs that because kids who came in and were deemed to be unaccompanied are governed by the TVPRA, which is a different statute. It's codified at 8 USC in 1232, but it's, you know, a detention authority. It's a statute that discusses detention and other provisions that's entirely outside of the INA for kids who are deemed unaccompanied minors. And because that is what is controlling their detention and their release, either if they're released before they turn 18 or if they're released upon aging out of OR custody, that if they are later redetained or subject to detention, you know, after they've been released from OR custody and after they've been deemed to not be a danger and flight risk, and that's why they're, you know, let go from OR custody, that the that Section 235B should not be applicable to them, that their detention should be deemed to be under 236. And that's still something that's percolating at the IJ level. I don't think anyone has gotten a decision about this from the board. Certain federal courts via habeas have also reviewed this and found some of these arguments to be convincing. So the real statutory hook here is the TVPRA. And Becca, did you want to just speak briefly about where you're seeing people getting picked up who are EUE and subject to this new policy?
Sure. Yeah. So these are, you know, the sort of the biggest, the most newsworthy are the folks that are getting picked up at the non-detained immigration courts. So people showing up for their immigration court hearings, those folks are getting picked up. Depending on why people are doing things like going to ICE check-ins. But it's also folks, people who are being detained when they're being picked up by ICE checkpoints. I'll also just say really quickly to the other question in the chat, people who entered on CBP1 were always subject to detention. This is not new. That was entering on CBP1 was not sort of a way to guarantee that you would not be detained, and so they're treated the same as anyone else who comes in at a port of entry.
I lost my mouse. And yeah, just to go back to Becky's section, you know, people who come in at ports of entry are deemed to be arriving right under the regulations. And so under the statute, they have traditionally been subject to mandatory detention under 235B. You know, as we might touch on as we go talk about the federal litigation on this issue, there are arguments being developed and successful about how folks in that position who have been redetained should be seen and what procedural due process rights they might have that might give folks with clients in that position and you know, arguments to present to a federal court for their release. But at the agency level, it's not really going to go anywhere.
And one thing I'll just say, Suchi, sorry, but because this has gotten more and more confusing, is when we say subject to mandatory detention under 235B, historically, yes, but also we're regularly released on parole. So you have always had clients that were subject to mandatory detention as arriving aliens, but weren't being detained because of parole directives and other reasons. So when we say mandatory detention, what used to be the huge carve out was parole.
That's exactly right. Yeah, thank you, Becca. That's helpful. Okay, so we're going to transition to talking about habeas, and Becky's going to walk us through a little bit of the landscape, and then and I'm going to talk a bit about the statutory arguments that people are making that have been successful, and Shiny's going to talk us through some of the due process arguments, remedies, and what it's like to kind of actually litigate these petitions. So, Becky, if you want to start us off.
Yes, thank you. We are in a new era for 235B related habeas litigation. At the beginning of this year, very few districts had ever even addressed any aspect of this statute. And since July, largely because of the change in practice within DHS and at the BIA, we've seen a remarkable explosion of individual litigation about what statute of detention actually governs when DHS claims that 235 applies. And this slide also lists a couple of the other more common types of claims that come up in 235 related habeas cases. The constitutionality of applying 235B, either provision, in any given case, including when detention has become prolonged, the validity of redetention or parole revocation, as Suchi mentioned, that leads to 235 detention, and also sometimes the validity of the warrantless arrest that leads to what the government claims is 235 detention. Next slide. Today, we are really going to be focusing on one type of case, though, litigation about whether 235 or 236 governs detention for a person who has entered without inspection. To date, since the spring, but largely since the Lyons memo in July, there have been positive decisions on this question from approximately 70 district judges in districts in every circuit except DC, and I believe this is an undercount as of this week. These judges overwhelmingly reject the government's argument that 235B2 applies to people who entered without inspection. Many of these cases relate to people who are having their first encounter with DHS years later, like Mr. Yahuri Hurtado, an interior arrest. But many also relate to people who were detained at the border and later released. So they're not limited to factual scenarios that are like Mr. Yahuri Hurtado's. And I want to flag there also is a very small handful of bad decisions out there. We count only 2 that reach the merits, and one of those is kind of different because it's largely focused on the deficiencies in the pleading. So really, I think we could probably fairly say 1 judge disagrees and 70 judges agree that this is unlawful. Next slide. And I do want to just flag that many of these cases also raise or address other legal issues, including the validity of the auto stay regulation, constitutional due process claims of a variety of types. Many of them include requests for preliminary relief, so you're looking at application of the TRO and PI standard. And then most importantly, for your purposes, some of these cases also talk about the proper application of expedited removal at all. And that's most often in a case where someone is in 240 proceedings, the government moves to dismiss and place them in ER and takes them into custody at the same time. And so some of the cases really mix up those 2 issues for fair reasons. And you want to be careful when you're reading cases to find cases to support your case, to make sure that you're not mistakenly citing a B2 case when you need a B1 case or vice versa. And the viability of a challenge to placement in ER is going to be very jurisdiction specific. There are jurisdictional bars in the INA that could apply. So I urge you to speak with folks who are more expert in the expedited removal context if you're going to be litigating one of those questions. There have also been a few appeals filed, notably in the 1st and the 8th, but no appellate court decisions yet. And here I'm just noting a few resources that may be helpful for people who are working on these issues. AIC and the University of Iowa are tracking these cases, and we're updating our spreadsheet that's public weekly. And we will send a link to that after the webinar, as well as links to these other resources. Thank you.
Thanks, Becky. So I think related to all these resources, there's a question here about the auto stay. This tracker, which as Becky said, we'll send out the link to, and it's publicly available, has notes about the auto stay where that has been challenged in individual petitions as well. And there's been a lot of success there as well. So I'll just briefly talk through the statutory interpretation arguments that are gaining the most traction in federal court. And so this all comes down to DHS's novel statutory interpretation of this section of 235, right? 235B2A. And that section has three very important components. And this goes to a question in the chat as well. It requires individuals to be applicants for admission, but it also requires them to be seeking admission, as Becky pointed out in listing the definition, right? And so courts that are examining the statutory language and DHS's arguments about what it means are really focusing in on the plain text of the statute. That has been a very powerful argument for a lot of courts. And in particular, honing in on this phrase, seeking admission, right? It's in the present tense, it's present progressive, and courts are using that in addition to a lot of other arguments and canons and construction to find that this is about people who are in the process of entering the country, right? This is about people who are presenting at ports of entry, or perhaps even people who are crossing the border outside of a port of entry, but who are in the process of doing so, right? They're near the border, they're at the border, not folks who are in the interior of the country, even if in some cases they have initially been apprehended at the border, but then released under what seems to be conditional parole under 236, not under 212D5, and are living their lives, right, in the interior of the country and then are redetained by ICE. So there's the plain text argument that's having a lot of success. And then there's this argument about the larger statutory scheme and context, right? And so this is, again, about what is the purpose of 235? What is it addressing? And it's about inspections, right? Inspections usually happen at the border, at ports of entry. And it's also, courts are also looking to what 236A says, right? And the fact that 236A also addresses, or 236 also applies to inadmissible non-citizens, right? And we see that in 236C, where it covers folks who are subject to 236C by virtue of certain grounds of inadmissibility, right? And courts are also pointing to Congress's recent passage of the Laken-Riley Act, which again includes grounds of inadmissibility. And that in order to avoid rendering huge portions of the INA and the detention scheme superfluous, you have to cabin the meaning of 235B2A. Another important point is the legislative history of ARERA and what Congress was actually trying to do when it introduced this provision, this language. And there's a lot of really helpful decisions discussing the fact that Congress was concerned about people who were entering, right, who were in the process of entering, really people who were coming in at airports without documents. So not the kind of population that is now being subject to mandatory detention under this really sweeping reimagination of 235B. And lastly, longstanding agency interpretation and practice, right? So as we've been talking about, the INS, DHS, the BIA all thought that 235B2 meant something very, very different and very much more limited than they do as of July of this year. And that is both a contemporaneous understanding and for 33 decades, 30 years, a consistent understanding of the statute, that it didn't apply to folks who've entered without inspection. And under the Supreme Court's decision in Loper Bright from a few terms ago, not only are federal district courts who are adjudicating this habeas petition seeing themselves as having this independent role to do statutory construction, they're also looking at the longstanding contemporaneous understanding of the agency and saying that that is a much more valuable tool than whatever the agency, DHS and the BIA are putting forth now. And I just wanted to, point to you can look at our tracker, as Becky said, there's over, 70 decisions, 70 courts that have ruled positively on this issue, but I just wanted to flag a few really helpful analyses from courts in recent days, including courts that, are not just in the First, Second, and Ninth Circuits, but outside of those traditionally liberal courts that have agreed with petitioners and disagreed with the government's statutory interpretation. So now I'm going to turn it over to Shiny to talk through some of the constitutional due process claims.
Thanks so much, Suchi. So in addition to statutory arguments that Suchi went over, challenging the government's categorization of their authority to detain your client under 235B instead of 236A, you will also want to preserve constitutional arguments that really, regardless of whether your client falls under 236A or 235B, their detention is or has become unconstitutional as a violation of their due process rights under the Fifth Amendment. And we've put forward this argument both in 235B1 cases involving arriving non-citizens and 235B2 individuals who are now being categorized as applicants for admission. So I know we were talking about 235B1 individuals briefly. I wanted to just clarify that these arguments are also available to them and have been successful in some districts. So just sorry, Suchi, could you go back? Thanks. So the Supreme Court has long held that the sole permissible purpose of civil immigration detention is to ensure that the appearance of non-citizens at future hearings and to prevent danger to the public. And there is a violation of substantive due process where the petitioner's detention is not reasonably related to the government's interest in protecting against flight risk and danger. And substantive due process claims are often intertwined with procedural due process claims, which has more developed case law. And in a procedural due process claim, the petitioner would argue that the procedures that are afforded to them, so in the 235B context, humanitarian parole, are inadequate to ensure that their detention bears a reasonable relationship to the stated purpose of mitigating flight risk or danger. So depending on the circuit, courts may apply a three-factor test under Matthews versus Eldridge, or a specific multi-factor test to determine whether detention violates procedural due process. So for example, I practice in the Second and Third Circuits, and the Second Circuit applies the Matthews versus Eldridge test to detention claims, both under 236A and 236C. And district courts in the Second Circuit have also applied now the Matthews analysis to 235B detention as well. And the courts have rejected the government's argument that there is a distinction between non-citizens who have lived in the country for several years and are later charged with removability from those who are stopped at or near the border and are deemed applicants for admission into the US. So the Matthews test involves three factors. The first factor is generally satisfied by the petitioner because the interest in being free from physical detention is considered the most significant liberty interest there is. Under the second factor, you have to show there is an erroneous deprivation because of the procedures that are used or are available to the petitioner under agency precedent or regulations. And you can argue that for folks who are detained under 235B, the only procedure that the agency makes available is humanitarian parole, which is a discretionary determination by DHS, who's not a neutral adjudicator. They're an adversarial party, and there's no opportunity to appeal that. And in practice, now DHS has either been ignoring parole requests or issuing summary denials without any individualized reasoning. And also, generally, it is difficult for a detainee to gather evidence and establish in a negative that they're not a flight risk or danger compared to the government, which has the resources to do so. And finally, under the third factor, you can argue that the government has an interest in minimizing erroneous detention when it serves no purpose, and the resources that the government is expending in detaining someone is substantial, and the resources they would spend in having to justify continued detention would actually be outweighed by the cost they'd save by reducing unnecessary detention or considering alternatives to detention. I will, next slide, please. I will mention that other circuits have applied multi-factor tests. So instead of Matthews, so it is important to check the case law and the circuit where you're filing the habeas petition, and the tests can vary. But courts have generally found that the most important factor to be considered is length of detention, and I'll talk about prolonged detention briefly in a bit. But other factors that courts have recognized, for example, in the Third Circuit, there's a case called Herman Santos that lays out a multi-factor test, includes likelihood of continued detention because of the length of proceedings before the IJ, and then the BIA, and then potentially a petition for review filed in a court of appeals. Unnecessary delays by either party, and this should not include your client pursuing their right to appeal, and whether conditions are meaningfully different from criminal punishment, and for which you can document conditions in the facility where your client is detained, for example, through a client declaration or through CRCL complaints or reports about conditions. And you can also check whether judges have found conditions in the specific facility to be akin to those in criminal facility as in other cases, and in some cases even worse than criminal facilities.
Again, I think this is super helpful when talking about prolonged detention, but in the context of these like statutory claims, which like the 235B statutory issue that might also have like a redetention piece or another like related constitutional claim, courts are generally using the Matthews test is my sense. Is that yours as well, Shiny?
I would say in the context of redetention, yes. But I think with prolonged detention in the 235B context, it depends. The court might go with a multi-factor test instead of the Matthews test.
Absolutely.
And thanks for that clarification. So we're actually going to touch briefly on prolonged detention and redetention in that context because some of the arguments can be different. So a typical scenario, I think actually up until recently, where this has come up is in the prolonged detention context, regardless of whether your client is detained under 236A or 235B. And courts have generally held there's no bright line rule to determine when detention becomes unreasonably prolonged. But courts have suggested that detention becomes more and more suspect after 6 months. But you might want to look at case law in your particular circuit or cases in your particular district court, because there are some courts that find prolonged detention long past 6 months and others that find just after 6 months. I think there's an argument again that this is an individualized determination. So we've seen the AUSAs sometimes argue that well, in this case, the court found 15 months to be prolonged detention, and you're arguing it's just 7 months. And in the sense, they're kind of creating this bright line rule by depending on this particular case. So you want to focus on how it is an individualized determination, but courts have found it's more suspect after 6 months. And even if your client has previously had a bond hearing before before the IJ, you can argue that that bond hearing itself was constitutionally adequate, or that the prolonged detention now requires additional procedural protections, specifically in the form of a bond hearing where the government and not the petitioner bears the burden to justify detention by clear and convincing evidence, and that a bond hearing that doesn't consider the petitioner's ability to pay and alternatives to detention to mitigate flight risk or danger is unlikely to result in a bond determination or amount that's reasonably related to the government's interests. And then very quickly on detention claims, this has become more and more common in light of recent courthouse arrests or arrests at ICE check-in appointments. This will often involve situations where DHS either release the individual at or near the border, presumably determining that the client is not a flight risk or danger, or where an IJ previously released the individual on bond, finding no flight risk or danger that can't be mitigated. But now DHS is redetaining the non-citizen without showing any change in materially changed circumstances since the prior release that's related to preventing flight risk or danger. And in fact, if someone's being arrested after attending a court hearing or an ICE check-in, that kind of also undermines flight risk concerns. And in many of those cases, courts have recognized that the lack of a pre-deprivation hearing before redetaining the person without an individualized determination that redetention is necessary, or that the petitioner have an opportunity to contest redetention, that's a violation of procedural due process.
Yeah, I think this is a really it's really great to see courts embrace these claims, because it's something that wasn't that commonly, I think, litigated or successful in years past, although they were certainly good decisions, and it's great to see courts recognizing this. And a lot of times, and I know you're going to talk about this next, is the remedy can be just outright release, right? And I think something to keep in mind here is DHS's decision to change its understanding of a fixed statute after 30 years is not a material change, right? That is something that they just pulled out of thin air. They haven't pointed to any individual circumstances in most of these cases that would warrant redetention.
That's a great point. And I'm going to skip over the next few slides. You can check our advisory that provides a comprehensive discussion about why a non-citizen detained under 235B has a right to due process to challenge their detention, regardless of whether or not they have a right to challenge admissions decisions. But there is a lot of discussion in the advisory distinguishing due process rights in this context from the Supreme Court's decisions in Thuraisigam and Meze. So I'm just going to...
Can I just interrupt you one more time? Because
Sure.
Ben, one grad who has filed a really great motion to reconsider, Yujure Hurtado, has a question here that I think could be useful, which is that can a habeas petition be based on a violation of federal regulations as distinct from the Constitution or the INA? And he points out that the regs themselves make arriving aliens, but not iwis, subject to mandatory detention. So Yujure Hurtado violates the department's own regulations. Do you have any thoughts about that?
Sure. You can also advance APA arguments as well, in addition to statutory INA arguments and the Constitution. arguing that the government's flip-flopping on this issue is arbitrary and capricious, or violates their own regulations, is not in compliance under the Carty Doctrine. So there are other arguments too that can be made.
I do want to flag on that point that like an argument that they're straight up violating the regs, I think could be difficult because the reg that says arriving aliens are not eligible for bond is not being violated like when someone who is not an arriving alien is denied a bond hearing. So I think a straight up they're violating the regs claim is going to be more difficult than using that as one of the reasons why their change in practice makes no sense because the regs are evidence of what their practice has been for the last 30 years. There is no reg about this barring bond for people who entered without inspection. But I think some courts might be hesitant to say they're violating the regs in those direct terms.
Thanks, Becky. I'm just going to end on discussing remedies. I think most people are wondering, so what relief can you get through a habeas petition? Why are we talking about all this? And it can be confusing. In some cases, you can ask for immediate release. So for example, in the redetention cases where your client was already released previously by DHS, or an IJ and the government hasn't shown a change in circumstances, or cases we didn't really talk about auto stays, but your client was granted bond and you're now challenging the application of an auto stay and DHS is now arguing your client is under 235B. You could ask for immediate release, but most often the remedy sought is that the government should provide a bond hearing within a set period, such as 7 to 14 days, which may or may not actually be helpful in your case. It kind of depends on the IJ. But if the detention has become prolonged, you can request a constitutionally adequate bond hearing with the safeguards I mentioned about burden of proof on the government, ability to pay consideration, ATD consideration. You can also try to make the argument that the initial determination should have also placed the burden on the government. If you don't just if you want to make that argument, I think some people might want to just get a bond hearing if they think their client will prevail and speed things up. But in other cases, if you're a bond hearing under the agency's precedent about the petitioner bearing the burden is not really going to help, then you do want to seek a burden shifted bond hearing. It just the government might push back and you might have to go through oral argument, which is something that, has happened in our cases. But if you have a bad IJ, you could consider just requesting the district court to conduct the bail hearing instead of the IJ. And there have been some district court decisions recognizing, courts have the authority, federal courts have the authority to hold such hearings, and some judges have actually conducted those hearings. And regardless, you want the court to maintain jurisdiction over the habeas petition, even if an IJ is conducting the hearing, because you could preserve an argument that if the IJ didn't really hold the government to its burden or didn't consider ATDs or ability to pay, you could seek a motion to enforce. And if the government doesn't actually schedule the bond hearing within a certain period, you can argue that they should just be released. One last thing I'll just mention, I know we're running out of time, but habeas petitions can move slowly in some jurisdictions versus others. In some jurisdictions, like the SDNY, judges will move fast, or the AUSA might agree to a quick briefing schedule. In other cases, judges may give the AUSA a really long time. So you should consider if temporary relief might make sense. And I think Becky or Suchi had mentioned TROs and PIs, but in some circuits, there are also specific factors such as extraordinary circumstances and/or substantial claims to support a request for immediate release pending adjudication of the habeas. So in the Second Circuit, the factors that are laid out is in Mapp versus Reno. In the Third Circuit, it's Lucas. So I just wanted to end with that as another possibility.
Thank you. That's super helpful, Shiny. I just wanted to elevate Karen's comment from the Q&A, which is that some courts don't allow burden shifting because of the regulatory language around that. And I just wanted to flag that, you know, in certain circuits, this question has been decided to some extent, right? In the First Circuit, all 236A hearings are burden shifted hearings. So if you win a habeas asking for, you know, with the remedy being a bond hearing in immigration court, it's already going to be burden shifted. But other circuits have ruled badly on this question, namely the 9th and the 4th. And so you want to be cognizant of that case law. There still might be room to argue in your specific case that a burden shifted bond hearing is warranted, given the specific circumstances, or, you know, depending on whether this client was redetained, absent changed circumstances, that the court should take that into account. Like, right, DHS is like past violations in their case, or something like that. But it's important flag to be aware of the general detention landscape in your circuit. So we are running a little bit out of time, so I'm just going to leave this slide up here for a second and very briefly mention that there are a number of cases challenging, some predate Yojuri Hurtado and some came afterwards, but challenging DHS's and now the board's interpretation of 235B. The only nationwide class, proposed nationwide class, we should say, is that we're aware of is Maldonado Bautista in Central District of California. And they are having, I think, a hearing on their motion for class certification in mid-November. But what's important to consider in all of these cases, including the regional ones, is that the relief sought on a class-wide basis is just this declaratory relief, right? And this is because of 242F1, which functions as a bar on class-wide injunctions for challenging immigration detention, you know, policies and practices. And so if the plaintiffs, petitioners in Maldonado Bautista are successful in, you know, getting nationwide class certification and a declaratory judgment, individuals are still going to, in most cases, probably most likely going to have to establish their class membership in order to get, you know, the bond hearing. And so in an ideal world, that would just mean establishing class membership to the immigration judge. However, given the much less than ideal world that we're living in, it very well might mean having to file something that looks like a really pro forma or template habeas petition saying I am a class member, and so I am, you know, I merit this relief, and having to go through that whole like process. But that's all kind of remains to be seen, and we're waiting to see what happens in that case and all these other cases as well. So with that, I think we can use the last few minutes for Q&A, and there's some questions in the chat that I will ask our panelists. Someone says, Benjamin asks, are people considered arriving aliens who are considered arriving aliens still subject to mandatory detention under 235B, even when a federal court finds their due process rights have been violated? Shiny or Becky, do you want to mention it? Take a stab at answering that.
I'm sorry, just to understand. I would say that for individuals who are considered arriving non-citizens and subject to and the court finds they're subject to 235B. If the court finds their due process rights are violated, then you can argue that depending on the posture of the case, but you can argue that they should get a bond hearing, or depending on the district, a constitutionally adequate bond hearing. But if the court determines that your client, for whatever reason, is not under 235B, which I think is a little harder when your client has been designated as an arriving non-citizen, you would then seek you would seek relief under 236A. I don't know if Becky, you have something else to add, but that is how I interpreted that question.
Tiny, did you want to answer the question about the government shutdown?
Sure. So someone asked whether the government, how the government shutdown has affected habeas petitions. I think most courts have while they've stayed some cases, they have excluded immigration cases and habeas petitions from that stay. So they're still moving forward, and I've seen AUSA still appearing for oral arguments and filing briefs, and the cases are still proceeding as they should.
Great. I think we're at time. I'm sorry that we couldn't get to everyone's questions. Thank you again for joining us today, and we will email out the slides and some additional links. Thank you all, and hope everyone has a good afternoon.